Patents are most appropriate for the protection of new technologies, and technologies can cover a broad range of subjects, everything from machines like computers or automobiles or whatever, to any kind of life sciences type inventions, chemicals. If I had an idea that I thought was worth taking to market, I would talk to somebody who's familiar with the patent system to find out what can be done with it, because almost any form of idea can, with proper consideration, be cast in a form that is patentable. There are some things that can't, abstract ideas, but almost any application of an abstract idea, which comes out in a machine, a chemical, a process, is patentable. It just, again, you want the right kind of thinking beforehand in order to make sure that you've got protectable claims when the time comes.
One common mistake that entrepreneurs make when they're first starting out is that they're filing their first patent application and they try and not only protect what they've invented and actually made, but they try and extend their patent further to all kinds of applications that they're guessing at, and guessing at broad applications. What can happen is that if they guess, unfortunately correctly, when they actually make that new and inventive application later, they could be shot in the foot by their first application, which they've hinted at this application. And patent offices around the world may deem their second application to be obvious or not novel in light of the first.
One of the biggest mistakes I see entrepreneurs make, especially people who are kind of going through for the first time, is trying to do too much by themselves. Patent help can be very expensive, but it's extremely important to protect patent rights from the start, and that takes effort and time and specialized training. I have seen too many people, I think, try to write their own patent applications and file them, and it's really difficult years later to support some of those patent applications. So most of us in the profession are used to helping people at the starting stages and are used to giving guidance and even helping out at the beginning to get you where you need to be from the start. But it's very important to talk to somebody and get the guidance early on so that 5-10 years from now, when you're a going concern and you've had your investment, you've got the applications and the patents that you want. Some of the dangers that I've seen are that entrepreneurs, who tend to be very bright and capable individuals, try to take too much on themselves in the early stages. And then later on, once the idea is kind of up and running and they're beginning to attract initial rounds of investment, it can lead to problems because the people who are making the investment want very carefully laid IP plans and implementations, and sometimes you're left scrambling trying to show them that the invention has actually been protected properly. We do deal with this quite a lot, and it can be a real problem, and it usually happens at a time when money is very tight, and unraveling the problems can be much more expensive and difficult than having prevented them in the first place.
The best piece of advice I could give an entrepreneur starting out is, first of all, many know that they shouldn't be disclosing their technology without first filing a patent application. However, if it's absolutely necessary, in some case it is, because some of these entrepreneurs are academics as well and they need to publish. So if you have to disclose, then do it under a non-disclosure agreement, but obviously the best course is to file a patent application before you disclose your invention to anybody.
Yeah, timing is very important for entrepreneurs in the invention or the protection of ideas, because the idea of the patent system is to protect ideas that are already not known to the public. So somebody that goes out, gets a good idea, but goes out and talks to investors, even to competitors, to somebody to help them develop the idea, may have placed the invention in the hands of the public. And on a worldwide standard, that's probably not patentable anymore, so extremely valuable rights can be lost.
After you file a patent application, you are protected against prior art from the date of filing. Therefore, after that, you can talk to investors and you can talk to anybody else about it. and you will be protected as of the original filing date. One thing to remember, though, is that patents don't actually issue usually for at least 5 years. After that date, you will actually be able to enforce it.
So, good evening, ladies and gentlemen. Welcome back to Entrepreneurship 101. A couple of quick comments at the beginning. I can't remember, I don't think I alerted you to the fact that at the beginning of this year that the United Nations has declared this the International Year of Chemistry. You know I'm a chemist, so I just thought you should all know that. But yesterday, our federal government declared this the Year of the Entrepreneur. So I'm feeling doubly blessed, but you should know that this is your year. So feel free to tweet your local MP. You could say thank you for recognizing everything that entrepreneurs do for the economy. And you could also suggest it would have been nicer if money had accompanied this announcement. Since you got recognition, but there are no funds for investment or anything like that. However, you should at least feel proud that the government has recognized that a lot of the recovery in the past year or so has come from small entrepreneurial businesses, and that they have woken up to the importance of this sector to the economy. So, to more relevant topics for tonight. Some of you will have seen at the back that we have copies of Canadian Intellectual Property Law for Dummies. We got a batch of, we got 100 of these, and we're selling them at our cost, which is $5. Okay? So if you're interested, they will be at the back, and if we don't sell out today, then we'll keep copies at the back over the next few weeks for anybody who wants to pick them up. However, given tonight's speaker, after tonight's lecture, you may not need this, given what Arshia Tabrizi is going to be talking about tonight. Arshia is a good friend of Mars and has been here at E101 in the past. He is the founding and managing partner of TLO, Tabrizi Law Office. And basically, Arshia advises startups in the IT and clean tech industries. And he is a technology lawyer, which is an interesting hybrid of business and intellectual property lawyer in one. I should tell you, he started out as a computer engineer with a degree at U of T. He has worked at IBM. But he fell off the straight and narrow and got into law, got a degree at U of T. I know him well, so I get to tease him on this. He went down to the Valley and he worked with Wilson, Sonsini, Goodrich, and Rosati, which those of you in the sector will know is one of the preeminent law firms in the high-tech business, and then came back to Toronto to open up Tabrizi Law Office in 2002. So he specializes in technology law and transactions, licensing, startup corporate matters, venture capital financing, internet and e-commerce law, as well as intellectual property counseling and strategy. But we've always asked Arshia to come here and not so much talk about the nuts and bolts of file on this date and do this, but to think of intellectual property as a business tool, because he is a business and IP lawyer, and it's not so much how to patent, but why patent, since it costs money, and how useful is this to you? So some of the experience, and as I was going through the details, of course, as a lawyer, none of the names of the companies appear here. So he has worked as counsel to one of the first nanotechnology spinouts from U of T, and a wide range of services to that company, which I know particularly well. Counsel to a Canadian internet startup, on structuring and negotiation of a multi-million-dollar cross-border acquisition by a large market-leading U.S. public company. So it'll give you a bit of a flavor of the sorts of companies that Arsha works with. And he has worked with a number of E101 graduate or Mars client companies over the past. So without further ado, over to you.
So can everyone hear me okay? Thank you very much, Tony, for that wonderful introduction. Very kind of you. So I guess we'll just turn to page 1. No, I'm just kidding. We won't do that. I'll let you guys read through it. Oops, we went back. Okay. So Tony already talked about what we do. I just do a little quick pitch on sort of some of the clients that we work with. And the reason I can mention this is because most of this is public knowledge now. So we basically do full service startup. I am not a patent agent, so we don't have patent agents in our firm, but we do everything else essentially that a startup needs. And we work with them basically from funding, just setting up the company through funding in terms of their IP strategy and hopefully through to exit. So I guess I'll start with posing this question is, what is a startup? The way I look at it is essentially all of you, if you're going to start a company or in the process, you're in the business of innovation. And this is going to tie into why we're going to talk about IP later. So what makes a startup is really the intangible assets that you have. So this could be an invention. So we heard in the clip before, whether you want to look at patenting something. Could be a brand. Could be software, could be know-how, whatever it is, it's really an intangible asset that you're building your business on, or a set of intangible assets. So what is IP, or what is intellectual property? And why should you care about it? Well, because IP essentially protects those intangible assets. So essentially, we're talking about something that's crucial to the success and building of your businesses. And how does it do that? Well, IP gives you a competitive advantage. And how does it give you a competitive advantage? Well, it basically provides you with a set of tools, which are legally enforceable, to keep competitors outside of a defined market. And we'll talk specifically about some of the different forms of IP and how they achieve that in different ways. But that's one of the crucial advantages of all forms of IP. The other thing I want you to take away today is that IP is intellectual property. So think about it as really your intangible piece of real estate. So I don't know, how many of you are homeowners here? Okay, a few of you. So you probably care about your house, right? You care about your real estate. You care about if somebody's maybe setting up camp in your front yard, you probably won't let them do that. So think about your IP in the same sense. Really, it's your intangible piece of real estate. It's the most crucial set of assets that you will work with as you expand and scale your business. So you have to take care of it. You have to protect it. You have to enforce it. You have to monitor it. And hopefully you'll take some little tidbits of knowledge to use as you proceed with your business. The other point, which Tony alluded to in his introduction, is that I always try and make this point to all my clients. Whether it's IP or any other sort of legal service that we provide or any other lawyers provide, ultimately we're really just part of your toolkit. So you have to just think about IP as a business tool. So really, the point is, what is this particular, if I'm going to spend some money, let's say, in getting this patent, or I'm going to spend some money in getting this trademark, or I'm put these agreements in place, what business objective is this serving in terms of my startup? You should never just go ahead and do anything, regardless, whether it's IP protection or anything else, unless you really know why you're doing it. Because this takes resources, both in terms of your time and financially, and it can be very powerful if it's used properly. So both in terms of cost and managing your resources, but also in terms of impact, right? Always think about what is the business objective that I'm after here. The other point I'll make is, and you heard a little clip before by my colleagues at Ogilvy Renault on patents, is that IP is not just about patents. So we're going to talk about 4 different kinds of IP, whereas patents are definitely the most potent form of IP, if you will. It's not the only form of IP. It's just a subset of different forms of intellectual property. So we'll talk about 4 different kinds of IP. We'll talk about trade secrets. We'll talk about copyright. We'll talk about patents. And we'll talk about trademarks. And hopefully we can get through them all during the lecture. And we'll leave some time for Q&A at the end. So IP form number 1. What is a trade secret? Well, trade secret is essentially 2 things. It's information of value, and it's information that's protected via secrecy. So it's actually very self-evident in the title that you use. It's a form of information that you protect by keeping it secret. What kind of information? Honestly, any kind of information. Any kind of information that you, as the business owner or the startup operator, consider to give you a competitive advantage and which you don't want your competitors to be aware of. So the reason I list those is because people tend to think about trade secrets more in terms of technical information. So, source code and algorithm, maybe a chemical process. But you also have to think that a trade secret can also be business information. So your business plan could be considered a trade secret. Your customer list, your pricing list, your product plans. So really any kind of information that you consider of value and that you wish to maintain confidential can be protected as a trade secret. So tip number 1 on trade secrets, and I'll give you 3 or 4 tips throughout the presentation, which I'm hoping will be the things that will stick in your mind. Again, you heard in the previous presentation about non-disclosure agreements or NDAs. So how many people have experience with NDAs or have been? So everybody knows about NDAs. So it's probably the most basic form of agreement that you will deal with as a startup enterprise. So essentially an NDA is a contractual agreement between 2 or more parties to treat certain information as confidential or to keep it in confidence, which means if you tell me something, I'm not going to go out and share it with somebody else, or if I do, it's going to be under certain conditions and restrictions. Where would you use NDAs? Well, you're going to use NDAs, for example, in terms of talking to potential partners, but you also have to think about even when you're looking to hire someone. So I see this a lot with some of my startup clients where they're starting up, maybe they have an idea for, let's say, a web company, and they're out there talking to people who they want to bring on board, whether it is as developers or advisors into their company. And really, this is the seed stage of the concept. And so a lot of times they will forget to get an NDA signed. So whoever you're talking to prior to really establishing a relationship, that's when you want to have an NDA in place. I've also listed investors. Now, a lot of my friends in the venture capital industry, and I don't know if any of you have come across this, will say, well, we VCs do not sign NDAs. And of course, the question is, well, why don't you sign NDAs? And the answer is, well, we see so many deals that we really cannot expose ourselves to potentially being sued by someone just because we happen to hear your idea. We may hear 20 ideas exactly like your idea, and we can't expose ourselves to that. So with a lot of institutional funds, you will encounter resistance in terms of signing NDAs. I think private investors or angel investors are much more likely to sign NDAs. And I'm actually doing a deal right now where we have a large private equity fund, and they've signed an NDA. So don't take their no, we don't sign NDAs for granted. The other thing that I want to point here is because of the prevalence of NDAs, people tend to kind of sign them without really thinking about it. People will go to a website, they'll download a form, or they'll get it from a friend, and be, okay, so I'm going to use this NDA. Well, there's a lot of little nuances in NDAs. And I don't want to talk about all of them, but the one point I'll make is you'll see that some NDAs or most NDAs should really be mutual NDAs. And what that means is it should protect both parties. So in other words, if you're the startup and you're dealing with a customer, let's say you want to discuss a potential product and you want to see if they're interested, you want to protect your disclosure, but the customer may also want to protect their disclosures to you. They may be talking about their business plans or what they're planning to do in the future. So they may not necessarily want to say, well, you can use all the information I disclose to you. So you really want it to be mutual. The danger I see a lot of times with startups is they don't realize that there's another form of NDA out there, which is a one-way NDA. What that means is you're actually protecting only one side of the negotiations or the discussions. And so a lot of times my startups will go in they will actually deal with a larger company, and the first form of NDA that's presented to them looks like a mutual NDA, but it's really not. When you really start to read the fine print, it turns out it's actually only protecting that bigger company as opposed to your disclosures to them. So, definitely make sure when you sign any NDAs that it's really both ways and it protects both sides. And read them, right? NDAs are there can be little tiny things in NDAs. I mean, I've had clients of mine who sign NDAs, and the NDAs have very heavy provisions on IP ownership, for example. So it might say something like, well, whatever comes out of these discussions, company A, I'm going to own it. So all of a sudden, you're thinking you're just having discussions and you're just exchanging information, which is going to be kept in confidence, but there's this overriding IP provision that can cause serious problems for you down the path. So even if you're not getting professional counsel, at least read through them carefully. So that was tip number 1 on trade secrets, and I went backwards again. Good thing I'm a computer engineer. There's only 2 buttons on this, and I still managed to hit the, okay. So moving on, let's talk a little bit about pros and cons of trade secrets. And this is really, in most cases, where you'll see the 2 forms of IP, which are kind of like mirror images of each other, or opposite sides of the coin, I should say, are patents and trade secrets. So a lot of these really relate to that. The big pro of trade secrets compared to patents is that you're basically keeping your competitors in the dark. There's no public, you're essentially keeping this stuff secret. So your competitors don't know what your algorithm looks like. They don't know what your invention is. All that they see is they see your end product. You can also basically keep whatever that information is a secret for an unlimited period of time. So in other words, if you look at and I use this example a lot, the Coca-Cola formula, so that form of IP protection, which is a trade secret, there's no patent on the Coca-Cola formula, is basically been around for decades. And so there's no timeline or deadline on it. What are the cons? WikiLeaks, right? So if somebody discloses that information and it's publicly available, that's it. The whole value of that trade secret is gone. The other thing that you should think about is reverse engineering. So if somebody actually purchases your product, or let's say they buy a copy of your software and they reverse engineer it, and through that reverse engineering they figure out what the algorithms are that you're using in that particular piece of code, say, then again you're out of luck. So IP, or the law around trade secrets, does not protect you against reverse engineering. And then one of the biggest cons is patents, right? So if somebody goes out there and actually patents what it is that you've been protecting as a trade secret, then again you could be you might be prevented from using that form of IP. So let's talk about patents. So what is a patent? Patent is basically a form of IP for protecting an invention. There's really 3 key legal tests that you have to meet. And this would be something that you'd have to apply to your particular invention with a view to prior art. So again, you heard in that clip a reference to prior art. So prior art is essentially everything that's been invented, whether patented or not, in that particular field. So whatever prior knowledge to what it is that you're seeking to patent. So the first point there is your invention has to be new. So you can't patent something that's already out there or been patented before. But that's not enough. You also have to meet the test of non-obviousness, which means your invention can't be just an obvious improvement on what's been patented before, or what's what's in the prior art. So I've given an example. For example, trying to patent a car with 5 wheels. So I'll just put 1 wheel in the middle of a car, which doesn't really do anything. That's an obvious improvement on what's there already. And then the final point is it has to have utility or some sort of commercial application. So why would you even want to get a patent? Well, patent basically gives you a 20-year monopoly from your filing date on that particular invention. So essentially, you get to have an exclusive market. You get to exclude every other competitor from practicing that particular invention. So it's a very, very powerful form of intellectual property. How do you get a patent? Again, I'm not going to go into details, as Tony mentioned. I'm not a patent agent, and really those are the people you should speak to, because that's all they do. They file patents. But essentially, you want to start, if you want to start yourself, one of the easiest things to do is to go on the CIPO website, which is the Canadian Intellectual Property Office, or the USPTO, the United States Patent and Trademark Office, and try some searches. See if there's stuff out there. What is, how busy is this field? That's one of the other things you'll hear patent agents say is like, is this kind of a virgin area that you're trying to go after, or is there tons of patents out there? But obviously, as always, it's always best to get professional advice, because the way that you read a patent is not going to be the same way that a patent agent reads it. Once you've decided to proceed with a patent, then you're going to work with your patent agent, and this can take months, believe me, to figure out what it is that you're going to cover. And typically, a patent covers two things. One is the description, which actually says what the invention is. But from a legal standpoint, the claims are really where you're trying to actually define the scope of the invention. And that's where a lot of the effort is going to go with your patent agent, to define the claims. In the previous clip, again, they talked about academic publishing. So it's important to note that in Canada and the States, you have a 1-year grace period. So it means if you're a prof or a grad student and you want to actually publish the results of, let's say, some research that you've been working on, you actually have 1 year from the date of that publication to file a patent. So this is and again, I should say, this is specific in certain jurisdictions. So for example, in a lot of European jurisdictions or elsewhere, you don't have that. So essentially, you should never disclose your invention before you file the patent. But we do have a 1-year grace period here. The other point is, a patent takes at least 3 years, 3 to 5 years to register. So you're going to be working with your patent agent to prosecute this patent through the patent office. So what you have to keep in mind is, during this period of time, at some point your application, and usually a year after you file, your application is now publicly available, which means anybody can actually go and see essentially what it is that you're invented. Technically, you have no right to actually sue an infringer of your patents until your patent issues, which means until you actually get registration. So keep in mind, when you file the patent, a year later it becomes publicly available. And so between that period and until your patent actually registers, you can't actually go to court and sue an infringer. So there is a gap there. Now, having said that, in the States, they have some what's called pre-registration damages. So you can actually have, if you put an infringer on notice, you can actually go back to the time where you notified them and the patent had become public, and actually claim some damages going back prior to the registration. But you still can't sue them until your patent registers. So the other point I want you to take away here is that the process of obtaining a patent is a long process. So again, going back to the point I made initially is, IP is a form of, it's simply a business tool. So you really should think about where you're trying to get your patents and whether it fits with what you're trying to achieve in your business. And this leads me to the next slide. So there's typically two camps in which you would fall when you're seeking to file a patent or obtain a patent. The first one is if you're really trying to take an aggressive position, and you want to obtain a patent in order to go out there and actually sue other people. So that's in the case when you're talking about some of these patent trolls, for example, in the States, which go out, file patents or buy portfolios of patents, and really their main objective is just to use the patents to go after infringers, either obtain damages or license those patents. So that's really the core business, is the patent itself. You have other companies in particular industries. So let's say if you're talking about biotech or certain high-tech companies like IBM and RIM, who want to aggressively enforce their patents, but they're also looking at ways to essentially keep their competitors out. So it's kind of like a deterrent. They're not really going to go out there and build a business on suing people around their patents, but they want to deter other people from entering their markets. In terms of startups, I would say there's really two key reasons I would say that a lot of my startup clients look for patents. And keep in mind, I work primarily in the IT sector, so I deal with a lot of web, mobile, software type companies. A lot of them feel that they need to have a patent filed in order to raise venture capital. And so for them, it's kind of a way of saying there is something innovative here. It's like a signal to the investors that there is something unique in what this company is doing. On the other hand, they're also looking to carve out the market, because from the VC's perspective or investors' perspective, they're also looking at this company and saying, well, this company actually is carving out an exclusive market around this particular invention. So that brings value, obviously, to the investors. What I always tell my startup clients is, the amount of money and resources that you're going to put into a patent has to really fit in with your business objective, because you can lose a lot of time. And believe me, I have a lot of startup clients who lose a lot of hours working on their patents. And when the patent is good, I mean, we just spent actually 6 months working on a patent with one of my clients and their patent agent. And this patent is absolutely crucial to their business. So it's really central to what they're doing. It's a fairly new area. So even if they're not really looking to go out there and enforce this, it's nice to actually be able to carve that out and keep other competitors out. So we talked about some of these pros and cons already. The second bullet there, no good guy defense. So what I mean there is patents are so powerful that when you file a patent and you get a registration for that patent, if somebody else sitting in their basement comes up with exactly the same invention, they've never seen your patent, they've never seen your product, they're still out of luck. You can still go and enforce your patent against them. So whether they're a good guy or a bad guy makes no difference. The flip side of it is you're basically, and this is the comparison between patents and trademarks, is when you file a patent, after that 1-year period, your patent is publicly available. So you have to appreciate that anybody then will be able to have access. You're basically telling the world about your patent. I just wanted to give you a bit of a sense of costs when you're looking at a patent. So if you're looking to file what's known as a full patent application, so you're really going to be looking at between $10,000 to $15,000 just for the filing. Now you can file a provisional patent, which is a shorter form of patent, which still gets you the priority date on your filing. And that patent can't, there are firms that will do that for about $3,000 to $4,000 to get you that, and then you can always do the full application later. So that's a way to kind of, for startups, manage the cost a little bit at the early stages. And a lot of times I do recommend my clients do that, because if the patent is central to what you're trying to achieve, then there is this middle ground of maybe spending a few $1,000s and filing a provisional. Where you at least don't lose that priority date. How am I doing for time? Okay? Okay. All right, let's move on to copyright. Copyright. So copyright is basically the right to copy, okay? It also has other rights, for example, the right to perform or the right to display a particular work. It is, interestingly, it's one of the few forms of IP that is essentially, well, it is the only form of IP, which is automatic on creation. So what I mean is you actually don't really have to do anything in order to own copyright. So if you sit down and you write a line of code, automatically copyright attaches to that. So you're already protected under the Copyright Act in Canada. These are some of the different forms of content that would be covered by copyright. And again, as with other forms of IP, what you're really doing is you're excluding competitors. So you're basically saying, this is what I've created. You cannot copy this. You cannot do anything that is similar, substantially similar to what I've created. And of course, you can license your creation. So if you look at some of the examples that I mentioned, in terms of the software industry, it's built almost entirely around copyright as a form of protection for that particular asset. Essentially, they derive revenue and make money by licensing that piece of IP. So Copyright. This is tip number 3, and this one is quite important with a lot of my startup clients, and they tend to miss it. Whether you're, if you're developing, let's say, a piece of software and you're hiring a bunch of consultants to help you with that, under the Copyright Act, you need to essentially get that copyright assigned over to your company. The reason being is that whoever the original creator or the author of a copyright always automatically owns that code or whatever it is that they've produced. So if you've hired a consultant, let's say, to develop your website for you. So they're sitting at their home and you're going to pay them something to develop this website and deliver it to you. That website, a priori, is owned by them. So basically, they've created it, they own it. So unless you get a copyright assignment, which has to be in writing, which means it has to be in the form of a contract, then you don't actually own that website. Now you might say, well, I've paid him for it, he's done it for me. Doesn't matter. Under the Copyright Act, you need to have a written assignment of that copyright. So this is very important, both in terms of your employees, but even more importantly in terms of your consultants or people that you hire as an independent contractor. So make sure you have written assignments in place. Again, pros of copyright. It's cheap. Basically, it doesn't cost you anything. Now, you can file for a copyright with the Canadian Intellectual Property Office. The only thing that gets you, it gets you a presumption of validity, which means it might help you in the event that you actually go to court. So you have basically this registration, which costs you, I don't know, $150, which says, yes, I do own this. But it's not mandatory, it's not required, and in a lot of instances, we don't do it, even for our clients. It's automatic, it attaches automatically to the work. Now, a couple of big downsides with copyright. First thing is it does not protect the idea. So again, you heard in the clip before my lecture about a patent basically almost covering any kind of idea, and you can basically essentially claim a monopoly over that concept or idea. Now, there are exceptions. So for example, abstract theories or formulae, so E equals MC squared, you can't patent that. There is even arguments around, for example, can you patent a business method in Canada? So just recently, I don't know if you guys know about the one-click order patent by Amazon. So recently there was some litigation in Canada, and the court said, we don't really have an exception for business methods. So in other words, business methods a priori can also be patented in Canada. That case is ongoing, it's been appealed, but there are some forms of ideas that can't be patented. But in general, that's really the power of a patent. Whereas with copyright, you're not really protecting the idea at all. All you're getting protection for is the expression of that idea. So again, to give an example from the IT industry, if you have 4 different companies implementing exactly the same algorithm, but via different pieces of code, they can't really claim ownership of the algorithm using copyright. So you can't say, I've written this piece of code, and because you're implementing the same algorithm as I've implemented, you're infringing my copyright. No. As long as they haven't copied your code, they're free to use the same algorithm. So that's one of the big shortcomings of copyright vis-a-vis patents. And so the point there is, you can only really enforce copyright against copycats. So essentially, independent creation is a defense to copyright. So again, going back to patents, where I talked about somebody sitting in their basement and coming up with exactly the same thing that you've patented, if you hold a patent, you can still enforce your rights against them. Whereas with copyright, independent creation is a defense. So in other words, if he's created exactly the same thing in his basement, he's free to do so. And there's no infringement of your copyright. And of course, enforcement. And we all know with all the peer-to-peer stuff and with music and all this kind of stuff, what's going on online these days with the internet, enforcement of copyright has become a serious issue. So, final form of IP. Are you guys still awake? Am I putting everybody to sleep? Yes, it's so exciting. Intellectual property. Okay. So, final form of IP we'll talk talk about our trademarks. So what is a trademark? Well, trademarks protect basically words and or logos. So, a company name, Microsoft, a product name, Windows, logos, the little Apple logo, the Nike logo. Essentially, any mark that is associated with a particular product or service can be trademarked. Now, registration for a trademark is territorial, same as patents. So in other words, you actually have to file in each. So for example, let's say if you're starting a Web 2.0 company, we would file for you in Canada, then we would also file in the States, and then depending on where you envision your other large markets being, we would file in those markets as well. So it's really territorial protection. Typically in Canada, we estimate between 1,000 to 2,000 per trademark. And usually takes anywhere, we've had actually trademarks issued within 3 months, which is unusual. Typically, we say you're looking at least a year. And so it's not a very expensive form of IP to obtain compared to, let's say, a patent. Why would you get a trademark? To stop somebody else from copying your mark or your brand. But more importantly, it's a little bit broader than that. So it's not just an exact copy, but you can actually prevent people who might be coming up with confusing marks or marks which basically lead the public to think that, is this the same company? Is this the same source? So let's say if I were to start my own mobile phone company, which I'm not intending to do, to compete with RIM, and I called my phones Cranberry. Okay, so that would, the BlackBerry trademark would essentially prevent me from being able to do that, because that would be a confusing mark. One tip to take away regarding trademarks. The number of times I've had clients come to me and say, I have this great idea for this brand, for this product, and I want to trademark it. I say, okay, that's fine. We can file for a trademark, but until you actually use something, you don't really have rights. So essentially, registration is not enough. I won't go into the details of the variety of ways you can lose your trademark rights, but the message here is, if you have a trademark registration or you're looking to get a trademark registration, you actually have to use that mark. And you have to use it both in order to obtain the registration and also to actually maintain your rights. So you could actually be using a mark today, you obtain registration, and then you stop using it for several years. Somebody could actually come and seek to basically invalidate your registration. So a trademark is only as good as your continued use. And the other point there is, make sure that you document your use, particularly if it's intermittent use. So again, if you have a website up and it's up all the time, you have the mark there. But let's say if you're selling product, and you're maybe selling 1 or 2, packages of this product with that mark on it, make sure you have proper documentation to support your use. And there we go. Now you can all wake up.
Very good overview of a complex area. Of the 4 types of IP, which ones really require vigilant enforcement? I mean, we're kind of aware of what McDonald's does under their trademark and Coke and this sort of thing, in order to keep your IP in place.
Good question. I'd say basically trademarks and trade secrets, in my view, would be the 2 where you really, if you're not monitoring and enforcing your rights, you could lose it. So for example, with trade secrets, if you're not ensuring, let's say that in your company, a particular piece of information is actually treated seriously as a trade secret. So one of the things which I didn't want to go into too much detail on this, but a trade secret is not a trade secret just because you say it is a trade secret. If you're actually going to court and you want to enforce your rights and say this is confidential information and it's been infringed or misappropriated by a third party, the court will actually ask you to prove how is it that you're treating this as confidential information. So things like, well, we have NDAs in place, we mark this information as confidential. Not everybody who walks into our office can just look at it, sitting on my desk. It's put away in a safe. So there are things that you want to have in place to ensure that it does meet the requirements of a trade secret. In terms of trademarks, again, if your mark is being what we say diluted. So in other words, if I'm Brim and I have BlackBerry, and you start a company called Cranberry, and then there's Blueberry, and then there's BlackBerry, and then there's Burberry. So now all of a sudden you have multiple brands which are confusing with mine. That can actually dilute my mark, and I might actually be losing my rights over time. So I'd say those are the two key forms of IP where you could actually lose your rights if you don't enforce them. Yeah.
You mentioned provisional patents. Could you give a kind of pros, cons summary of those, like you had done with the other ones? So what are the disadvantages of filing a provisional patent? What are the advantages? Are there any?
I don't know if I'm the best qualified person to answer that, again, because I'm not a patent agent, but I'll give you my view on it. Well, the first obvious disadvantage is you're not doing a full patent application. Okay, so you're kind of cutting it down a bit. The other issue too is, I believe, and again, don't quote me on this, but what you put in your provisional may potentially limit what you can actually put later in your full patent application. So you also have to be careful, and one of the things I've seen with actually quite a few clients is they try and even cut corners even more, and they file their own provisional. So you have to be a bit careful about that. It is a cost-effective way of getting that priority date, but you also still want to have some professional input into the provisional itself, because it might actually impact what you can add on when you actually go to the full patent application. So typically a provisional, essentially what it is you don't have the full set of claims. So if you look at a patent application, there'll be a description, and then you'll have 30 pages of claims, right? And so with a provisional, what you're doing is you're not doing the full set of claims. So you're not defining the full scope of the invention, but you're trying to put something that's broad enough that permits you in the full patent application to go in and then say, okay, and now here are further details, right? So you still probably want to be careful, at least make sure you get professional advice, essentially, on the provisional.
Hi. If you could comment on filing patents and trademarks in Canada as opposed to the US and the EU, and how do you kind of protect your rights internationally? Is filing in Canada sufficient? And secondly, if you could maybe briefly comment on licensing of patent pending IP.
Okay, so in terms of your first question, so there are a variety of treaties in place, both for patents and trademarks, which permit you to start filing here and then file internationally. So you can basically claim priority back to the date of filing in Canada. So for example, in terms of trademarks, we typically have 6 months. So we'll file in Canada, and within 6 months, we have a window of opportunity to file in the States and then claim back to Canada. Okay? So, I mean, I don't want to go into all the details across the board, but essentially the message is you can claim priority back, but there is a timeline on that. So you can't file in Canada and then just sit on it and then say, well, 10 years later, I'll file there, right? You might lose the ability to claim back your priority date. Sorry, what was your, okay, so licensing of patent pending inventions? Oh, if you can get somebody to license your patent pending invention, then I think it's good for you, right? I mean, I've had people approach me with that. Honestly, it's not an area I'm an expert in. But what I tell people is, I mean, if I was the licensee, I would basically want to be assured that your patent's going to issue if I'm going to pay anything for it, right? I mean, if you think about it this way, is you don't really have any real IP until your patent issues or is registered. So if you say I've just filed a patent and now it's patent pending, I mean, the office actions, the scope of your patent, maybe you filed something asking for the world and they're going to bring you down to this. So if I'm the licensee and you're telling me I have patent pending on this, I'm like, that doesn't mean anything to me. I've looked at the prior art, you filed this. In my view, this is going to come down to this. So how can you actually negotiate, let's say, license fees when we don't even know what the scope of your final patent is going to be, right? So I think that's where the challenge is with that.
Hi. What about patenting business plans, in particular in the internet industry? For example, years ago, before blogs came along, what if I thought of blogs and I wanted to patent that? Is that something that could be patented?
Well, without commenting specifically on blogs, in general, you can patent business methods, right? So there's no, and right now in Canada, I mean, in the States, you've been able to patent business methods for a while. And in Canada, we have as well. But now we have another decision which basically says you can. So there is no a priori exclusion of business method patents, if you will. But you'd still have to meet those requirements, right? So, some would argue, and this is one of the issues that came up in the Amazon case, is, for example, the one-click ordering. Well, is that a non-obvious improvement on what there was before? I mean, is it really inventive? So it's new, it wasn't there before, but is it really inventive? So I guess the answer is there is no a priori exclusion of it, but you'd still have to try and meet those tests as with anything else, right?
Yeah, as I stated, a patent gives you a monopoly of 20 years of a kind of field of technology. Now, being now a new entrepreneur in a technology field, making a startup, so it takes probably 5-7 years, industrial scaling, blah, blah, blah. So you probably earn in 5 or 10 years money. And then you have only 10 years to earn your money. I mean, what I don't like is that I want to extend a monopoly not only 20 years, I want to extend it, for example, over the whole 21st century. So what kind of advice you would give? So you would make every 5 years a new patent which covers a little the old or the new stuff, or how would you say? So
there's certainly improvement patents, or there's a variety of forms that your patent agent can work with you based on what you have and what else is being patented, what the prior art is, to actually keep trying to extend that, right? But I mean, the original patent that you filed, that scope will be gone in 20 years. But my question to you is, I mean, what business are you in? Are you starting a company? No. What industry? No, because I'm just curious, because it sounds like patents are very central. I mean, are you in biotech? Are you in?
No, it's
chemistry.
Yeah, it's clean tech. It's
okay.
It's green stuff. And,
yeah, absolutely. So I think
which is probably coming now, not only the next 20 years, which can have a long range,
Yeah. Absolutely.
And this is the stuff that you would lose after 20 years. You're in a monopoly.
Absolutely. So there are.
Then everybody can copy it and.
No, absolutely. So if you're talking about long-term development things, so that's why, I think Tony was mentioning, for example, biotech, chemistry, nanotech. I mean, patents are, I mean, these guys spend, some of these companies, even startups, they spend, hundreds of thousands of dollars in filing their patents. So because you're talking about such long-term development cycles, then patents are quite useful. And you want to be able to actually extend them.
How potent and enforceable are NDAs in practice? And does case law in Canada or the United States have precedents where a party to an NDA has actually stolen the idea, brought it to market, and then been successfully sued? And second question, unrelated, on software, what's the best way to protect software other than copyright, given a skilled programmer can recreate function easily and not violate the actual coding?
Okay, good question. So, sorry, your first question was?
First question was on
NDAs, enforceability
of NDAs, yeah.
No, NDAs are enforceable, and people get sued on them all the time. I think the issue with NDAs or enforcement of NDAs, multiple factors, but one of them is what I referred to before, which is to say you can't just by saying, this information is confidential and you've signed an NDA, that's it. There are exclusions to confidentiality. So for example, if that information becomes publicly available, otherwise, that NDA is no longer enforceable. You can't enforce confidentiality because that information is no longer confidential, right? The other thing you get into is, and you'll see a lot of NDAs provide for this other carve-out is in the event that that party claims that it's independently developed the same thing. So if you're IBM and you've spoken to this department in IBM and you've signed an NDA, and then a year later you find out, this other office or department of IBM has developed the same thing, and you go and you say, hey, you signed an NDA with me, I'm going to sue you. These guys are going to say, well, yeah, but those guys over there in our Austin office, they didn't have any access to your stuff. They just happened to develop the same thing. And now you get into evidentiary issues, right? Because now they have to prove that they actually did not have access to your information, and then you have to prove that they did. So you do get into, a lot of these things are going to turn on evidence, but essentially an NDA is an enforceable agreement. And so by all means, and most definitely, get NDAs signed and don't just rely on, I have a witness here in the room talking to you, right? The other thing too is, there's different forms of disclosure, right? So you'll find in some other NDAs, for example, there's a distinction between written disclosure versus verbal disclosure. So, to the extent, let's say if you have a business plan or a product idea, or let's say a set of specs. So your company is ABC Inc. Okay, ABC Inc., these are my specs for this product. I'm talking to a potential manufacturer who's going to make this for me. You email it to them. So now you have a trail, and this is a written document. If you go to court and you want to enforce your NDA, here's my set of specs, which says confidential, and here's a copy of my NDA. As opposed to, here's a copy of my NDA, and yeah, I met with this guy in his office, and we had a conversation, and I told him about my business. Okay, well, he says that meeting never took place. What do you have to corroborate that meeting? So verbal disclosures get a little bit more difficult, which is why you want to have somebody else in the room as a witness potentially, or sometimes NDAs, and when you're dealing with some large companies, which are very process-driven and which are very worried, because think about it from a big company standpoint, they're also concerned about startups just coming to them, having meetings with them, and then saying, well, this is confidential, now I'm going to sue you, because they have thousands of projects going on in the background, and they may be working on the same thing. And so some of them are very, very careful about putting in place processes for documenting even verbal disclosure. So they will say, there is no verbal disclosure, does not count as being covered under the NDA. Everything has to be documented. And if you think you told me something that's confidential, 5 days later, you send it to me. I agree. We both initial and we sign off, and we confirm that this information was disclosed between us. So you can get into all kinds of nitty-gritty processes. But in general, NDAs are enforceable. Then your second question, I rambled on for so long. What was and your second question was about, software. Okay. Maybe I overstated my point. Copyright is the primary form of protection for software, but software is equally protected by trade secrets and or patents. So, you're definitely, I'm sure that your source code, if it contains, proprietary stuff, which I'm sure it does, that you're going to be treating this as a trade secret. So not everybody can go on your server and pull the source code. You're going to have user IDs and passwords, so you're going to prevent people from accessing that, right? So I don't know if am I kind of answering your question there? And of course, there's patents on software as well. Yeah. Oh, sorry, yes.
If your IP is work in progress, so I've heard so many years back, if you're working on something, if you want to protect that, write it on a piece of paper, mail it to your address, and keep that unsealed, unopened. So let's say you have a patent that's work in progress. What is the best way to collect evidence? Let's say if you're working on it over the course of 2 years, to say that, yes, I started working on this before you did. Nothing?
No, so I've heard this from a lot of people, but the point that I would make to you is that it doesn't really matter, right? So in the sense that if you're working on this for 5 years and you have all in your notebook and you're mailing yourself and you're documenting, creating a trail that you've came up with this first, doesn't matter. If I filed a patent first, I'm ahead of you. It doesn't matter if you invented it first, because we're not in a first to invent system, we're in a first to file system. So that's why what you have to think about when you're coming up with something is, okay, there's always a risk that somebody's going to file. So what you want to do is you want to make sure that at the very least you maintain it as a trade secret, right? So, if you're discussing it with somebody, make sure that you have an NDA in place with that person, right? Or, make sure that access to the information is limited, or don't tell anybody about it until you get it to the point where you're going to file, right? But we are not in a first to invent system, so it's not really going to play into the legalities if somebody else files a patent before you do. Okay. All right. Sure. Thank you.